Good evening. Welcome to this edition of the Evening Review. My name is Jemima Beatrice, your host. Now, we had an interview earlier this week, just right after the Supreme Court hearing for the presidential election, but brought on by Dr. Panduleni Itula, who is the president of the Independent Patriots for Change. Now, the court convened on Monday to hear this case challenging the results of the 2024 presidential elections. And Dr. Panduleni Itula and Bernardo Swartboy of the Landless People's Movement, both that are contesting this outcome, a main argument is the legality of President Nangolo Mbumba's decision to extend the voting period beyond the original date, which was the 27th of November. Now, Dr. Panduleni, represented by Senior Counsel Anton Katz, a South African advocate, argued that the Electoral Commission of Namibia, the ECN, unlawfully extended the voting period through a presidential proclamation. Katz, who represents Dr. Panduleni Itula, contends that only the ECN has the authority to extend voting and that such a decision should have been made before polling stations opened and not afterwards. He also argued that the extension violated the Electoral Act as well as the Namibian Constitution, therefore rendering the election results invalid. Now, Dr. Bernardo Swartboy, the leader of the Landless People's Movement, was represented by also South African Advocate Counsel Camille Premid, who also supported the argument brought on by Advocate Katz that the President's extension of the voting period was unlawful as the Electoral Act grants the presiding officer and not the President the power to extend voting for those that were already in the line at the closing time. He Premid argued that any extension must occur before voting begins, and extending it after polling stations have closed is unconstitutional. Now, President Nangolo Mbumba, who was represented by Advocate Raymond Heathcote, his defense was that the President's decision to extend the elections was within the President's powers and did not at all infringe upon any of his rights. He also dismissed Dr. Panduleni Itula and Bernardo Swartboy's opposition claims as unsubstantiated. Now, the Supreme Court will give its hearing on the 28th of this month, February. And as you know, there were allegations of widespread malfunctioning of machines. And in fact, the extension the election was extended because there were not enough ballots and because people could not find polling stations where they could vote. It was either closed because it was never opened because of irregularities. So now we sat down with Dr. Panduleni Itula to get a glimpse into what he believes is the future for the IPC, should they not be granted a rerun, or what he believes the future holds for them if there is a rerun. So please join us as we listen to him.
Right, thank you very much. One of the most important things of a nation state is that we must have a population, a boundary, but also the most important thing is an ability for self-determination, an ability to make relationship. And a nation state as we are has got three organs: the legislative, the executive, and the judiciary. And today we saw how the judiciary came together to adjudicate on a grief of a member of the public, whether it's now a judicial person or a juristic person or a natural person. And what we are hoping to do is this: we don't want Namibia to turn out to become an authoritarian regime, because if that happens, then it means that a lot of the basic principles of democracy will not be recognized. Human rights, for example, will go throughout the window. And at the same time as well, as a constitutional democracy, it means that a free, fair, and credible, lawfully conducted election is a critical ingredient of constitutional democracy. And what we are aggrieved by is the lack of a free, fair, credible, and lawful election. And although the court today did not look at the massive information that was there in terms of evidence, what we concentrated on in this case, in terms of the IPC's case as it were, is the legality of the president to issue out a second proclamation claiming to amend the first proclamation. Now, in terms of Namibian law, when the ECN realizes that there is a need for an election for the president or National Assembly, they approach the president with a date and say, Your Excellency, could you proclaim this one as the polling day and polling date 1? And they've done so in terms of Section 64, subsection 1A, B of the Namibian Electoral Act. Having done so, they then realized that somehow mid-straight into the electoral day of the 27th, things were not going right. Things were not going right. One, that there was not enough ballot papers, that some of the polling stations didn't open on time either, and also some of the voters were not processed quickly because the verification equipment, which was also not statutorily allowed to be done, were freezing and they were not done. Now, the first thing is that before the election took place, there was a voter registration to determine how many people are eligible to vote in Namibia, and 1.8 people were registered. Now, out of that 1.8 people that were eligible to vote, only 1.4 registered to vote. That is critically important because it determines how many ballot papers can be printed. And armed with that figure, the 1,400,000 ballot papers. In addition to that, they had to print 10% as a contingency. But they have already determined that what is the total population in all the 121 constituencies, each constituency. Now, in terms of Section 98, subsection 1 and subsection 6, it says that you are only allowed to vote in the constituency in which you were registered. And that's critically important because that ring fences whoever coming in not to vote in there, unless by reason of absence in their constituency, they can be accommodated there, and they can be accommodated by way of a tendered vote. Now, because you knew how many people registered in the constituency, and you went to print the number of ballots for that constituency plus a contingency of 10%, you should, as a matter of fact, never have run out of ballot papers because you've got the correct number and you've got a 10% contingent plan there. And some of the stations ran out of ballot papers, like Fingerstein, for example, which is less than 10 kilos from the capital where the warehouse is holding the ballot papers. But those stations have not been replenished with new ballot papers, although the court argument was principally the proclamation. Now, when they realized that they don't have enough time to get everybody in, they then extended, the voting period from 9 o'clock to whatever time it was that the CEO of the Electoral Commission did. Now, after that, they consulted, they say, with the Attorney General, and the Attorney General is only supposed to be an advisor, legal advisor, to the President and the government, not to an agency of government, as it were. So the ECN is supposed to be completely an independent, transparent body and not linked to anything else. Nonetheless, they consulted them, and then they advised them to extend the days and hours of balloting. And so they went to the President, who then issued out a new proclamation using the same authority by the power vested in me by Section 64 1B. I hereby extend the voting period from the 21 hours of the 27th to the 21 hours of the 30th of November inclusive. Now, there isn't any provision in the Electoral Act that in an event that the 1 day is not sufficient, you should extend the voting day and hours to another day. The court, the legislator, and that's why these organs are important, the legislator, having considered that Namibia had 2 polling days initially, could not see that there would be security of the ballot overnight. And that's why they decided, let's only have one polling day. Do it there, finish it, close off, and that's the end of it, and count, etc. So they went from 2 days to 1 day with that reason. And there is no provision in the Act that says that in the event that the election does not take place completely and you encounter problems during this time, then you should come back and then we'll extend the time of voting. And this is where the illegality process started now. And that is what we were arguing. The question is, if the extension of polling day from 1 to 4 is unlawful, the entire election is unlawful. And if you can separate the lawful conduct on the 27th from the unlawful one, that's fine. But it's impossible because no one can see which ballot were cast by which date, etc. So that is the argument from the other side that says that, okay, give us the 27th, and that 27th will allow us then to accept the polling day and the election. But what we are saying is the entire tree and its fruits is poisoned. You can't separate it from each other. So that is the main argument that was in the court today, to determine if the court were to find that the second proclamation, which is intended to extend the voting hours and the voting time by the president in the absence of a power to so exercise that proclamation and issue it, if the court finds that to be unlawful, illegal, and contrary to the Constitution and the electoral laws, they should set aside the entire election. And if they found on the other side that it was not illegal, etc., then they need to make the decision. And that's basically what the arguments were. The question of the, in terms of Section 1,
explore the beauty of Namibia with our car rentals. From wide open spaces to the plains of Namibia's national parks, enjoy the freedom of the open road. Go anywhere you want, whenever you want. We've got you covered, even in the most remote locations. Visit our website and see what we have to offer.
It all began with ink on paper, a small but powerful voice that reached the homes of Namibians, sharing their stories, their triumphs, their struggles. As the world evolved, so did we. From the presses to your screens, keeping you connected to the news that matters, wherever you are. We didn't stop at digital. We brought the action to life on your screens, covering the moments that unite us all. We're not just a source of information. We're your partner in exploration, booking your stay, paying for your meals, and even sending your event tickets straight to your phone. Reaching over 1 million people daily, we are a fully integrated system, working together to make your life easier. Whether it's news, events, or everyday information, we've brought it all together. We're committed to empowering the next generation. Through partnerships and innovation, we're delivering education to every corner of Namibia. We've become so much more. More than news, more than information. We're here to help you enjoy everything Namibia has to offer. NTV, so much more than just television.
Now, welcome back. If you've just joined us, we had an interview with Dr. Panduleni Itula, the president of the Independent Patriots for Change, IPC, earlier this week, right after the Supreme Court hearing on Monday, where Dr. Panduleni Itula, alongside Bernardo Swartboy of the Landless People's Movement, brought on a challenge of the presidential elections of 2024, arguing that the extension of the voting by President Nangolo Mbumba was unconstitutional, violated the Electoral Act, that the president has overreached powers that was only that of the presiding officer of the ECN, and therefore they want the court, the Supreme Court, to declare these elections that were held, the presidential elections, null and void and invalid. Thank you. Let's continue.
Set aside an election if it appears to the court that the election was conducted in terms of the principles in Part 5 of the election was such that we, in our argument, did not even get to 115. 115 it's only valid when there is a lawful conduct of the election. And here we are saying that there was no lawful conduct of the election, and consequently, the conduct of the election was illegal, and any provision that prohibits one to set aside an election would be irrelevant for consideration's sake. Now, I could see the argument of the other side going on about the irregularities and the social medias and all the others. I'm not the judge. But what I'm saying is that what we ask the court, and we are the applicant to do, is to tell us just one thing. Was the proclamation illegal or not? Now, the reason why the cases are two, one in the Supreme Court and one in the Electoral Court, is because in terms of Section 166, the Electoral Court is given a broad authority to adjudicate any contravention of the Act. However, in terms of Section 172, the Supreme Court is given authority by Parliament to adjudicate on disputes pertaining to the return or the outcome or the search for information pertaining to electoral material of the presidential election. So, Section 168 of the Electoral Court is a broader one. This one says you can do that, but when it comes to president, you bring it here. And this is the reason why the case has been presented in two courts. The Supreme Court also serves as the constitutional court. And therefore, the Supreme Court also, the Electoral Court also said, let's postpone our determination of this case until such time that the Constitutional Court made their determination. Because if the proclamation in terms of their judgment of the Supreme Court is unlawful, unconstitutional, illegal, and everything else, then the presidential elections will be set aside. If that is the case, it goes without saying that the same proclamation that empowers the election of the National Assembly will also be set aside. But the Supreme Court has got no powers to set aside a National Assembly election. Only the Electoral Court, which is a division of the High Court, can do so. Therefore, they will be acting on an adversary note, possibly from the Supreme Court, to say that if the Supreme Court, which is actually the appeal court, the apex court, has made a decision of that nature, then it means that the National Assembly could ask the parties to endorse the decision of the Supreme Court and order a re-election in the National Assembly elections without having to go to trial. And that is a possibility. Or they may say, okay, but if the Supreme Court does not pronounce it yearly, it has got 14 days, not counting Saturdays and Sundays and bank holidays or public holidays. They need to pronounce themselves in 14 days, which will be the 28th of February. However, should the Electoral Court hear the case, they must give their determination in 72 hours, and that is according to the law. So as a consequence of that, we've got this situation. It's more likely than not that the Supreme Court may give a determination yearly. Now, the Electoral Court of the High Court is going to sit on the 20th, and when they sit on the 20th, they are going to determine exactly, it's a case management, how they will go about it and determine a date when they are going to sit to hear it. And it goes without saying that it's more likely that they will await the judgment of the Supreme Court before they actually have a hearing date. So they may say our hearing will be on the 1st of March. Now, one of the things that has been brought up is the Independence Day. 21st of March is an Independence Day that was determined in 1978 by the United Nations during the passing of Resolution 435. They gave a timeline from cessation of atrocities and violence to returning of the refugees, to campaigning, to voting, to then constitutional, and then declaration of independence from Constitution Day, which is today, to the 21st, then to prepare for the inauguration and independence. So the 21st is only an Independence Day. It's not a constitutional date determined in the Constitution as an inauguration day. The inauguration of a president and the parliament in Namibia is dependent on a free and fair, credible, lawful election conducted that yielded a president and members of the National Assembly. Then there will be an inauguration. Should, however, the Supreme Court order a rerun of the entire election, the 21st will become irrelevant. People may decide to have an Independence Day, but the term of office of the current president or acting president and the term of office of the National Assembly will terminate on the 21st. And thereafter, there will be nothing at all. The court can come up with one or two things. They may decide that, okay, let's make sure that we have a rerun of the elections before the 21st. Or they may say, we'll give you 90 days in terms of Article 57 and Article 29 of the Namibian Constitution. In the absence of a president, including a president-elect, there will be 90 days to elect a president. And that is a principle in the Constitution that they may well follow. If that is the case, then we are looking at May, June as the day that there will be a possible rerun or something like that, because everything comes into preparation. But if they decide that, no, keep the proclamation, all we need to do is just go and determine a voting day. Then a time has to be determined where ballot papers will be printed, and then preparation and campaign and everything else, including who's going to sponsor the money for campaigning. May well be that the court may actually say, yeah, as they did in another case, ECN, you need to pay for the campaign of every single political party. So it's not feasible to determine at this stage what the court will decide. That is for them. But the argument that was in the public domain and which was all over social media is those basic ones. Consequentially, we will have to wait for another 14 days before the Supreme Court make their decision, but we are going back to court in the Electoral Court on the 20th to determine exactly what the situation shall be in the Electoral Court itself. And that's where it is now. Whichever way it goes, whether we go back running again or not go back and running again, I am convinced IPC will still be the winner, will still be the first party to have been in existence for 4 years, contest the national elections, and become the official opposition party. But there's only one little thing. I, as president of the party, is not on the parliamentary list of the party. But there is no way in the Constitution or any other Namibian law or rules or procedures that says that the leader of the largest opposition party in parliament must be a member of parliament. There is no provision for that. You may now for the first time find a leader of the official opposition who only comes to parliament to respond to the State of the Nation address or to respond to a bill by the Prime Minister and not sit as a member. You can come in as a stranger according to the British system of parliamentary debate, so you can come in as a stranger. But you'll still be entitled to all of the other things. Not that that is important at all. It's just to say we have got a dilemma as to how that is going to be done. And that dilemma came about because, one, in Article 17, there's a provision which says that you can participate in the conduct of public affairs, whether directly, meaning as a presidential candidate, or through freely chosen representatives, meaning members of parliament. And because it says whether directly, is disjunctive. And that is the reason why I didn't contest both, because it would be in violation of that Article 17.